So, from Delhi to Chennai, the governor is making headlines and not always for the right reasons. Be it stalled bills, denied assents, or public spats with the chief ministers, one question looms large in the Indian politics. Is the office of governor still relevant, or is it time to remove or abolish this colonial vestige? Hi everybody, I'm Advocate Varun Dutt and I welcome you all to this in-depth examination of one of India's most debated constitutional offices, the Governor, where we explore the origins, powers, controversies and the ongoing debate. Should the office of Governor be abolished or reformed? Let's dive deep into this constitutional conundrum. Why this topic is relevant today? If you can look at the slides, see, there have been a lot of cases, news headlines, as well as issues with respect to conflicts arising between governors, as well as the chief ministers or the council of ministers, as visible in the newspapers and so on. See, Tamil Nadu 2022-23, we see governor withheld assent to 10 plus bills without any explanation and even making controversial public statements. West Bengal, we see repeated public disagreements with the CM Mamta Banerjee as well as the governor. Maharashtra 2022, we see a controversial floor test happening where certain news headlines even alleged a role of the governor in regime change in 2022 that aided the fall of the Mahavikas Aghadi government of Uddhav Thackeray. Then again, Punjab and Kerala, we again see delay in the bills, giving assents to the bills, which led to constitutional standoffs between the duly elected government of the state as well as the constitutional post of governor. Now, the core issues out here are, this delay in assent is resulting into an account veto without an accountability on part of the governor. There is, a regular interference happening into the day-to-day governance of these bodies or the council of ministers, the governments at the state level. There are instances of misuse of Article 356 happening while recommending the presidential rule. There are partisan public statements happening, and all this has resulted in trending headlines related to this issue, which are going to the extent of speaking governors acting as agents of the center, which is a clear-cut allegation and a very big allegation for that matter. There are headlines on the row over delayed assent to the bills, or there are even petitions in the Supreme Court. Can governor delay an assembly session or not? Long story short, why does it matter? See, the governor's functions or the governor's actions are increasingly being questioned as being violative of the federal principles, democratic accountability, and the constitutional spirit of cooperative federalism. Let's quickly look at the constitutional role of the governor first. See, Article 153 to 162, they deal with the provisions with respect to the office of the governor. Okay, the governor is essentially a nominal executive, a de jure executive, or de jure executive head of the state. Okay, sorry, it is the council of ministers led by the chief minister, which is the de facto or the real executive when it comes to the state. As far as their appointments are concerned, they are appointed by the president on the advice of Union Council of Ministers. Okay, and even though the constitution provides them a 5-year term, but in a sense, they work at the pleasure of the president, or in reality, pleasure of the Union Council of Ministers. They can be removed at the sweet whim of the president whenever they so wish. If we look at the functions and powers of the governor, see, first is the executive sphere. In the executive sphere, he is the executive head of the state. All executive actions of the state are taken in the name of the governor. Then he appoints the chief minister as well as the other ministers in the council of ministers on the aid and advice of the chief minister. He allots the portfolios amongst these ministers as well as the chief ministers. So all executive actions are taken in the name of the head of the state or the governor in the case of India, which, unlike the parliamentary system present in Britain, wherein along with the governor, the concerned minister also signs or is equally responsible for the actions. That is not the scenario here. Then if we talk in judicial sphere, see, under Article 161 of the Constitution, the governor has the power to provide pardon, reprieve, respite and remission of the punishment against the state laws. Then he has power to suspend, remit and commute sentences given to any persons against the state laws. And this power, however, is limited to those offenses which have been punished under any particular state law. They do not extend to any punishment or any sentence which has been given under a union law, nor do they extend to any sentence or punishment given by a military court, or any sentence or punishment given for a federal crime, and so on. Then there is a third and very relevant sphere of the legislative sphere. In the legislative spheres, he summons and prorogues the sessions of the state legislature every year. Then he dissolves the state legislature at the end of the session of 5 years, or if he thinks the Council of Ministers led by the Chief Minister has lost the confidence of the House. He has a very pertinent role under Article 200 to give assent to the bills, wherein he can give assent, withdraw assent, or not take action on the bills. Okay, or resend it back to the House for its consideration. Then under Article 213, just like the President of India, even he has the power to pass ordinances when either or both the houses of state legislature are not in session, and the governor is of the view that there is a pressing matter which needs an immediate legislation. Then in the legislative sphere, we have the discretionary powers, or rather, even apart from the legislative sphere, also we have discretionary powers. Some of these actions can be connected with the legislative acts of the state legislature, or other actions he has a complete discretion in other parts also. Let's see, Article 163 of the Constitution, it outlines the discretionary powers of the governor. It essentially states that the governor must act on the aid and advice of the Council of Ministers, except in cases where the Constitution requires the governor to act in his own discretion. So what this provision essentially is speaking is that while in normal circumstance the governor is to act on the aid and advice of Council of Ministers, but he is not completely bound. He can even act on his own discretion if in his view the circumstances warrant such a behavior. Okay, these circumstances or these discretionary powers, however, are not unlimited. The governor, even though he can exercise his discretion, he can exercise this discretion only in specific situations, such as appointing of the chief minister, when no single party after the completion of the election has secured a clear majority, or any coalition has not secured a clear majority. In such circumstances, the governor has the discretion to call either a single largest party or the party or coalition who he thinks has the maximum chances of successfully forming a government at the state level, to come and form the government and establish its majority through a floor test. Okay, then reserving bills passed by the state legislature. Under Article 201, the governor has been empowered to reserve certain bills for the consideration of the bills passed by the state legislature for the consideration of the President of India. Then there is recommendation of President rule under Article 356. See, if the governor is convinced that the state government cannot be carried on in accordance with the provisions of the Constitution, or he is of the view that there has been a failure of the constitutional machinery in the state, he can send a report to the President of India, or either suo moto, or if he is called upon to send such a report by the President, and accordingly the President can impose a President rule on that concerned state. Then finally we have the discretionary power of dissolving the legislative assembly. As I mentioned before, if the governor is of the opinion that the state government or the government at the state has lost the majority in the House, and despite losing this majority, it is either not facing the floor test or refraining from the floor test or not resigning, he can himself remove that government from office and power on the basis of the fact that it has lost the trust, the confidence of the House. Now, one thing we must remember with respect to these discretionary powers is that if any question arises as to whether a matter falls under the governor's discretionary power or it does not fall in those discretionary power, the decision of the governor is the final decision. As to this decision-making power of the governor with respect to discretionary powers, this particular decision that whether a particular matter falls within his discretionary power or does it not, his decision will be final and it cannot also be challenged in a court of law. Okay, now as to his constitutional provision, or rather constitutional position, the Sarkaria Commission made a very interesting comment. It said that the governor is like a bridge and not like a wall between the center and the states. But if we see the present day realities, unfortunately, even though while the governor is nominal head or a de jure executive in our scheme of things, their discretionary powers, or rather the improper use of these discretionary powers, has often become controversial point of political interference. See, if we look at the key Supreme Court judgment with respect to the role of the governor and the stand that has been taken by the apex court through its various judgments, we clearly see a line emerging out here. First off, we have Shamsher Singh versus State of Punjab, a 1974 judgment wherein the apex court said that the governor is a constitutional figurehead and he must act on the aid and advice of the duly elected council of ministers of the state. Then we have SR Bommai versus Union of India, a 1994 judgment where the apex court held that the misuse of Article 356 based on a governor's report can be struck down, and the apex court allowed a judicial review of his action by stating that a mala fide intention based action of the governor, or rather a report which is based on extraneous or mala fide circumstances, is totally justiciable and can be looked upon into by the Supreme Court for upholding justice. Then we have a case of Nabam Rebia versus Deputy Speaker related to the Arunachal Pradesh Assembly, a 2016 judgment, very very relevant for our particular topic of presentation. See, in this particular case, the court has held that the governor cannot interfere into the assembly proceedings or preempt the decisions of the speaker, and his power to summon the assembly is subject to the constitutional checks laid down in our constitutional document, and he cannot suo moto or on his own discretion, without any aid and advice of the council of ministers or speaker for that matter, summon an assembly session as per his own whims. Okay. Then we have the case of Rameshwar Prasad versus Union of India, a 2006 judgment. Here also many relevant points were laid down. First off, a judicial review of Article 356. See, the imposition of President rule under Article 356 is totally subject to judicial review. Governor's report, which forms the basis of such President rule, is not immune and can be tested for mala fide intentions as well as extraneous circumstances or irrelevance. Then the court laid down that there are limits to the discretion of the governor or the governor's discretion. He's not an agent of the center and must not act so. He must rather act within the constitutionally defined limits of his powers. Okay, where there's a mere apprehension into the mind of a governor as to a horse trading going on for making a government at the state level, such a mere apprehension is, in the view of the Supreme Court, totally insufficient a ground to recommend the dissolution of a duly elected assembly. In fact, in this particular case, the Supreme Court, it went ahead and declared the decision of the governor unconstitutional. However, it refrained from reinstating the government, which was removed it did so only on the ground that the elections had already been notified and it was not right to reinstate the government in that particular circumstance. Okay, then we have the case, a very very recent case of state of Tamil Nadu versus Tamil Nadu governor. Herein the governor had delayed giving assents to the bills and had sent certain bills for presidential recommendations. He delayed the assent for over 3 years when repeatedly asked, and when the state government was forced to take recourse to Supreme Court, he withheld his assent to these bills. Eventually, the court had to interfere into the matter, and court laid down the clearly mentioned timeline wherein which the governor must take decision as to whether he wants to give his assent or not give his assent, or send the bill for presidential consideration and so on. Then we see the case of government of National Capital Territory of Delhi versus Union of India, wherein the lieutenant governor in this particular scenario was deliberately impeding or blocking the exercise of its constitutionally given powers by the government of National Capital Territory of Delhi, which eventually forced them to seek recourse to Supreme Court. And Supreme Court interfered and told that even in case of NCT of Delhi, the governor is bound by the aid and advice of Council of Ministers, and he must act on the aid and advice of the Council of Ministers. In fact, in a later judgment between the same two parties, the Supreme Court also stated that the services, or rather services which are forming part of the bureaucracy of NCT of Delhi, form part of bureaucratic machinery and are under the direct control of the government of Delhi. And Lieutenant Governor cannot suo moto take charge of their functioning or decide as to how they will function or how the appointments will be done on these services without taking recourse to the aid and advice of the newly elected government. See, long story short, if we look at these judgments, then these judgments clearly show that the judiciary has repeatedly warned against the governor's overreach and tried to put legal boundaries on his use or misuse of discretionary power. However, if we look at the facts and the trends, the ambiguity, despite these judicial efforts, this ambiguity still persists. So, as far as the core of the debate is concerned, what are the arguments for abolishing the office of the governor? There are certain points which have been put up by the critics. See, for starters, it is a colonial legacy which has been borrowed from the British Raj. Now, we must remember during the British days, the governor was primarily serving as an imperial agent. Now he's serving as a bridge between center and state and a primary block for ensuring coordination. Okay. Anyways, despite the colonial legacy, this particular office has nevertheless retained under the scheme of Indian Constitution. And despite retaining it, the constitutional safeguards provided to ensure its smooth functioning have been very, very few. And thus the critics often argue that it is not suitable for a mature democracy like India. Another thing that is said is that this office undermines elected state governments. See, the governors, as I said before, are not elected by the people, but their powers to withhold assents, their power to veto the bills, it can override the state's democratic will by delaying or denying the bills or dissolving the house or dissolving the state governments for that matter. Then one another important point is that they are often alleged to act as a political agent of the center, clearly violating the federal spirit. Then there have been as I've said before, there have been clearly so many examples of a misuse of their discretionary powers by the governor, and this has been persisting for time immemorial. In case of the independent India, if we see, they are delaying assents to the bills, such as we saw in case of Tamil Nadu and Kerala. They are refusing to summon sessions, such as we saw in case of Punjab recently. They are engineering defections, as we saw in case of Maharashtra. They are openly making wrong statements or controversial statements with respect to a duly elected government, as we saw in case of Kolkata, and so on. And then finally, we see the point on breaking the spirit of federalism. See, the misuse of their powers of assent as a pocket veto sort of, or as a pocket veto tool. It weakens the autonomy of the states by center's unelected appointee and who is intervening in the state's governance. And this essentially, this action or this suo moto action of the governor invariably breaks the spirit provided by the constitutional feature of federalism, which is a part of the basic structure of our constitution. Okay, and then finally it is said that this being a colonial legacy and primarily a ceremonial office, its redundant ceremonial duties can be better handled by certain other offices, such as that of Chief Justice or Speaker and so on. Okay. So just as there are arguments in favor of abolition of this office, there are certain arguments against the abolition of this office or in favor of keeping this office. First, we see there is a constitutional safeguard for unity. See, governor ensures constitutional functioning and acts as a bridge between the center and the states, as well as a vital link in the cooperative federalism. Okay, then we see when it comes to emergency roles, he reports on the ground realities during the constitutional crisis, such as during imposition of emergency under Article 352, 356, and so on. Moreover, he can assure constitutional propriety in hung assemblies or in case of a constitutional crisis in a state assembly. Okay, then he acts as a buffer against legislative misuse. See, he ensures that the laws that are passed are constitutionally valid, especially the private member bills that are passed. They also need to have a governor's assent, and then he can act as a check upon misuse of these private member bills for personal motives. Then finally, it is said that since this office is essentially a ceremonial role, so it does not really require a complete removal of the office. As a ceremonial head, he can, ease transitions during unstable regimes. Moreover, the people in favor of keeping the office argue that since he's anyways a ceremonial head, we can always retain his office with reduced powers or with redefined responsibilities of this office. So, the gist of the debate is, should we abolish, or instead of abolishing, can we reform it or not? When we look at the reforms which have been suggested by various committees and commissions and so on, see, for starters, there was this very important Sarkaria Commission which came on center-state relations, which came on in 1988. It really made a very important statement that the governor must be politically neutral and said that governor must not be from ruling party at the center. Then again, the commission said that the appointment of governor should be with the consultation of the chief minister of the state where he's getting appointed. Then the commission stated that the governor must be an eminent personality and with no active political ties. There must be a cooling off period before some person who has been retired from politics is appointed as a governor. And more importantly, governor must be from outside the state so that we can ensure freedom from bias. If somebody has played an active political role in a particular state, then there is always that possibility of he having a particular bias in favor of a particular party while performing his functions as a governor. Then finally, the commission even suggested guidelines for the use of discretionary power of the governor. Okay. Then we have a Punchhi Commission on Center-State Relations. It, amongst other things, fixed a tenure of 5 years, stated that the fixed tenure of 5 years which has been laid down in the constitution should not be disturbed arbitrarily. The governors must be allowed to complete their constitutionally provided tenure of 5 years, okay, and should not be removed or dismissed from office on the whims of the center. Then as regards assenting the bills is concerned, the governors, they should not return the bills repeatedly. If a legislature has resent the bill, the governor must subscribe to the will of a duly elected legislature of the state and give assent to the bill unless it is totally contrary or in contravention of the provisions of the constitution or against the spirit of democracy or certain principles forming the basic structure of our constitution and so on. Then the Punchhi commissions talked about restricting the post-retirement roles of the governor in order to ensure the presence of any sort of bias in their functioning. What it says is that once a person has retired from his position as governor, then just as constitution provides with respect to many other constitutional dignitaries or constitutional offices, in case of governor also there should be some limitations with respect to offices which he can hold after retiring from his post, so as to ensure that there is no bias in his functioning while he is seated at his office. Okay, then we have the recommendations of National Commission to review the working of the Constitution, which, or rather, the Venkatacharya Commission, as it is famously called as. It gave its reports in 2002, and it essentially called for a depoliticized merit-based appointments and only eminent individuals from outside the state with no recent political activity should be appointed to this post of governor. Then again, the commission stated that they should serve for a fixed tenure at the office for a fixed tenure and should be removed from their office only on the constitutionally mentioned grounds. They should not be arbitrarily removed as and when the center so wishes. Okay. Then the commission talked about clear procedural conventions. For example, strict timelines with respect to passing the bills or withholding the assents and so on. Then it talked about, restrictions on the discretionary powers of the governor. See, the discretionary actions of governor should be acceptable only in constitutionally specified scenarios. Those scenarios should be clearly mentioned in the constitution. And beside the provisions which have been given in the constitution, the governor should act very, very cautiously and without any sort of outside advice or without any sort of center's diktat while performing his job. Okay. Then governor should not delay forming a government or withhold his assent to a duly passed bill which is within the constitutional premises and constitutional peripheries. Okay. Then if we look at certain constitutional experts and so like experts like Fali Narman, Soli Sorabji or Harish Salve, they all have constantly stated the one thing. Okay, there has to be a clarity that is needed in the role of the governor, and more importantly, they've all advocated for reforming the institution of governor instead of abolishing or removing that office. Okay. Now, once we have learned the pros and cons of the debate, we can even look at the proposed reforms or solutions that are possible to improve upon this office. Okay. See, for starters, we can fix the tenure of the governor. We can remove the doctrine of pleasure from the office of governor, wherein he is removed at the sweet will of the union central government. If the governor must be allowed to complete his constitutionally mentioned 5-year term so that we can ensure that he performs the duties of his function without any sort of bias. Then we can have a transparent appointment process of the office of governor. These appointments should be, if possible, through a bipartisan committee or some sort of federal council where we can clearly see, that the center does not choose its favorites while making appointments to the post of governor. Then we can lay down clear guidelines with respect to the discretionary powers of the governor as well as lay down the clear constitutional limits within which they are supposed to be functioned. We can lay down clearly, a time-bound procedure with respect to giving or not giving assent to the bills so as to ensure that they are duly passed. Then if possible, we can try to ensure that there are no political appointments made, so that the person who is coming does not have any sort of prior political bias with respect to a particular political party or a political coalition. Then finally, we can improve upon the judicial oversight. We can allow immediate review of the questionable decisions on part of the governor, and so on. See, if we look at the global practices also now, there also what we come across is that even in similar democracies such as Australia, Canada, where similar sort of roles are performed by the governors, we see that even though the offices of governor exist there also, but they are by and large ceremonial and with codified norms. Okay, now although we talked about the reforms that are possible, but there are a certain set of challenges also. For starters, there is no constitutional compulsion as per the norms or the provisions of our constitution to follow the reports of all these commissions or news headlines or the reviews or views of the authors and so on. Then appointments under our current political structure are still done on the basis of political convenience to the government at the center. Then the fact that there is an insecurity of tenure in the mind of governor, it goes on to ensure a compliance of the governor towards a diktat of the center. And then finally, we do at times come across a lack of public as well as media scrutiny when such issues arise. Okay, if we talk about the way forward, what are the ways how we can take this office from here and evolve it to a much better office? See, we can either amend the constitution, we can thereby clearly define the scope of discretionary powers as well as mechanism to prevent its arbitrary exercise by the governor. We can, provide for a mandatory consultation with the chief minister with respect to appointments of the governor, or we can introduce clearly defined terms as well as constitutionally mentioned removal safeguards, such as we have in case of impeachment of the president, so as to ensure that they are not arbitrarily removed from the office. Then at the same time, we can build transparency mechanism, such as where the governor's office is taking any controversial action, its reasons for that action must be clearly documented as well as made public. Then the governors must act as constitutional guardians and not as political operatives. Then constitutionally provided checks against the center misusing the office of governor for its own personal profit and so on. Okay, so to conclude, the nutshell of this debate is, again, the same line that the one with which we started. Should we abolish the office of governor? Answer, as per me, is no, not necessarily. Abolition, it may throw the federal baby out of the colonial bathwater, but reform is indeed very critical. The institution must evolve with time and with changing democratic expectations. In a vibrant democracy, unelected functionaries must not overpower elected governments. Okay, let the governor be a constitutional sentinel and not a political puppet. What do you think? Should we reform the governor's post or should we remove it entirely? Please do drop your comments in the reviews in the comment section. See, India is a constitutional crossroads. The governor's office, once ceremonial, now shapes the politics of India. So it's time for us also to shape this particular debate. Okay, please like, share and subscribe if you do believe in that the democracy must evolve with time. And please hit the bell icon if you want to stay updated on similar governance, policy and UPSC related content. Thank you, take care and have a very great day.